Hello, and welcome back to Miss Jana's Learning Cafe. Today I wanted to chat with you about some basics of law that govern special education. I am not a lawyer, so I'm not offering any legal advice of any sort. I do have 15 years of teaching experience as a special education teacher, and I'm also a parent of several kids who are receiving services. My oldest and my youngest daughters had an IFSP for speech when they were in preschool. My oldest son is currently on a 504 plan. My youngest daughter currently has an IEP for a specific learning disability, and my youngest son is on an IEP for speech. Having sat on two sides of the table, I feel like I have a lot of information to offer. So let's talk about the basics of the law. Special education is governed by the Individuals with Disabilities Education Act, or IDEA. This law was originally passed in 1975 as the Education of Handicapped Children Act and has been revised twice. Amendments to the law were put in place in 1997 and again in 2004. First of all, to even be considered for special education, a person needs to meet specific criteria in one of the categories. These categories are autism, blind visually impaired, communication disorder, deaf and blind, developmental delay, deaf and hard of hearing, emotional or behavioral disorder, intellectual disability, multiple disabilities, orthopedic impairment, other health impairment, specific learning disability, and traumatic brain injury. Those are the 13 categories. Students can be referred to a special education services by a parent or a general education teacher. This referral goes through a child find team that usually consists of the special education director of the school, a general education teacher, a school counselor, and the special education team. This team looks at data, conducts testing with parent permissions, and follows a process called response to intervention. Once it has been determined that a student has a disability based on one of those categories, the team needs to look at the impact that disability has on education. Depending on the needs of the student for services, accommodations and modifications made to core curriculum, frequency needed for supports, and the discrepancy between the ability and performance, the team, which now also consists of the parent of the child in question, determines if special education services are required. Sometimes students will qualify in a category, but their education is not being impacted. The team would determine that special education wasn't necessary, but might put a plan into place to allow for some supports. An example of this is a student who has a medical diagnosis of autism, is able to communicate with peers and teachers to express their needs and wants, and their lowest grade is a C. This student might need some support, such as extended time to complete work or an alternate place to complete assignments for tests. They would not qualify for special education services, but might be placed on a 504 plan. When it is determined that a student has a disability and it is affecting their education, an individualized education plan, or IEP, can be proposed. Once a student has been placed on an IEP, the team will determine the specific goals they will work towards in the next 364 days. Progress towards these goals are to be reported to parents as often as general education students receive grades. Who will perform the services, how often, and the length of those services is also determined. Accommodations and modifications to the core curriculum and the classroom environment are also determined. An IEP is reviewed and updated every 364 days, and a reevaluation takes place every 3 years to make sure the student still qualifies and is receiving all of the services they need. Once this IEP is signed by all members of the team, it becomes part of the law. If any part of the IEP is not met, students and parents are asked to bring it into the attention of the teacher first, then the special education teacher or director. If corrections are not made in a timely manner, the parent can start the legal due process. As a teacher, I've only been involved in a handful of times that the state was contacted with a complaint. We've been lucky, and as a team we were able to work out the issues and avoid any court proceedings. IDEA also states that students who have been identified with having a disability should be allowed access to a free and appropriate public education in a least restrictive environment. If a parent doesn't agree with the testing evaluations performed by the school, they are welcome to seek outside evaluations and bring the information to the school. Schools also encourage medical paperwork be brought in so that they can see the whole picture of the student. Parents can accept or revoke services. Once on an IEP, students will need to test out of the classification area, or parents will need to revoke services. Students have until they graduate high school or until they turn 21 for the IEP to legally end. It doesn't follow them into college or trade school, although many schools do take into consideration that the student was receiving services. I hope this has clarified a little bit of the law IDEA and what it what it covers.